For judgment, item number 1.
Going into the other grounds raised in the petition, this court is that the include detention order dated 15/1/25, condemnation order dated 64/25, and the extension order dated 14/7/25 cannot stand the test of law in view of the foregoing justice court as information and according to Quashing of FIR.
Oblige.
Well, His Lordship, my Lord, I beg to mention item number 26 on behalf of Livica, my Lord. Your Lordship may kindly list the matter on 22/9/2025 on Monday.
26.
26, 27, and 29 on Monday.
26, 27, 29, Monday, on the prayer of Mr. Tibapom, on behalf of Ms.
Livika.
Livika, learned PP. Learned counsel for the petitioner has no objection.
Yes, my lordship.
Lordship, interim may kindly be continued, Lordship.
My lord, again, I beg to mention hearing item number 35, 36, and 37 on behalf of Livika. Let the matter become up after puja, my lord.
No objection, my lord.
My lord, again, I beg to mention item number 42 on behalf of Inaholi, my lord. Let the matter be fixed on 23/9/2025. Yes, Tuesday, yes. Taken the consent, my lord.
Okay. It is informed that the consent of the petitioner has been taken. Stop, please.
Much obliged.
No, please, Your Honor.
Yes.
I beg to mention item 2 on behalf of V. Sopre. We have taken the consent of the petitioners.
Yes.
We pray that the matter may be listed after 2 weeks.
Okay. This is the matter after 2 weeks. Item 2. List the matter after 2 weeks on the prayer of Mr. M. Longkamar on behalf.
Two weeks. Your Honor. They are absent today, Your Honor. They have informed. Obliging.
Well, please, my lord, I beg to mention item number 3. Here, Your Honor, on the last occasion, respondent 5, 6, and 7 were directed to file an affidavit. And then accordingly, they filed, and then now they have stated in their affidavit that now the two departments, they are before the Treasurer's accounts, Treasurer's office for a pre-audit. So let it may come after 3 weeks, Lord.
This is for that area.
Yes, Lord.
So that means it's complete.
Not yet, still they are under process. So let the candidate be kept pending.
You're going to get it. Yes, anyway. Learned counsel for the petitioner, Mr. S. Walling, who is prayed for listing the matter after 3 weeks in view of the fact that the process for payment of the arrears is now in the office of the Treasuries and Accounts. Stop. Accordingly, list after
1.
Obliged.
May I please, Madam? I beg to mention item number 38. I'm appearing on behalf of respondent number 4, my lord. Today, my senior has some personal difficulties. If this matter may come after 1 week.
for R4. Learned counsel, Mr. I. Jamir. Yes.
It can be listed after 2 weeks, then, Your Lordship.
2 weeks.
I have no objection.
Learned counsel, Mr. I. Jamir, who submits on behalf of the, who's the leading counsel?
TB
The leading counsel, Mr. T.B. Jamir, for respondent number 4 to list the matter after 2 weeks. So, learned counsel for the petitioner has no objections. List after 2 weeks.
Lordship, there is an interim.
The interim order passed earlier shall continue till the next date.
Obliged.
May I please, Your Lordship? I beg to mention item number 41 on behalf of my senior. Kindly fix this matter on 14th of October.
Matter on 14th October. Stop. Learned, what about respondents? Learned counsel for the.
I filed my affidavit also. After 2 days. Much.
I beg to mention item number 4 to 23. Lordship will be filing our reply in the course of the day. So let this matter be listed after 2 weeks.
You'll be filing your reply.
Yes, in the course of the day.
Okay. Your learned counsel, Ms. You are?
Intila.
Tila Pongan. for the petitioner who submits that the respondents have filed their affidavit in opposition and should like some time to file the affidavit in reply. Stop. Accordingly, list the matter when?
2 weeks.
After 2 weeks. Stop.
Much obliged.
My Lord, I beg to mention item 25. My Lord, here I may be given 3 weeks' time to file my additional affidavit. Item 25. My Lord. Three weeks' time, my Lord. Also, item 40, my Lord. My Lord, here it is a consensus prayer that the matter be listed on 23rd of September, my Lord.
Obliged, my lord.
Obliged, my Lord.
For admission, item number 1.
Your Lordship, I only have the verbal instructions if that will be accepted by this Honorable Court. Yes, Lordship. Now, Your Lordship, as per my instruction, under a normal circumstance, we are actually one of the institutions that has to function according to the policies framed by the state respondents. However, there are exceptions, Your Lordship. And an exception here in this case is that it is a case of termination by the Annexure C of the writ petition. The service was terminated with effect from 1/12/1992, and the fresh appointment took place after 45 days, that is 15th of January 1993. So there is a, regardless of whether it is a 1-day break or 2 days break, it doesn't matter. When the earlier service has already been totally discontinued and a fresh appointment has been made, and the order that is the Annexure C the order dated which date is this, sir? 18th November 1992. No, this is the order that terminates them with effect from 1/12/1992.
The order that terminated them.
Yes.
Yes.
So this is 18th November 1992. Now, even assuming that if this order is to be accepted, there should have been some sort of corrigendum or addendum that this order has been amended or modified. No such step was also taken by the state respondents. So there is clearly an interruption in service. Now, interruption in service, Your Lordship, to understand that we go to the state's affidavit, the Annexure 5. Annexure 5 of the state's affidavit. Annexure E, sorry, Annexure E. Annexure E, paragraph 6.
Annexure E, the OM.
Yes, the OM.
Paragraph?
Paragraph 6.
6, yes.
Now, therefore, it has been decided that a period of service rendered on ad hoc, contract, work charged, substitute basis, which is followed by regularization or regular appointment without break or any gap in service except resignation, shall be treated as public under the Nagaland Retirement from Public Employment, Second Amendment Act 2009. This, if we have to give a wide general interpretation, it appears to show that all sorts of gap in service or break in service is already covered. But here, the situation is unique. service was terminated effectively, positively, the language itself. So when there is already a termination in service, that explanation is not even covered by Rule 27 of the CCS pension rules. I may be allowed to read the exceptions where service continuity can be counted.
That is rule
Rule 27
27.
of the,
CCS pension rules.
yes,
1972.
1972. May I read, Your Lordship? Rule 27, effect of interruption in service. An interruption in the service of a government servant entails forfeiture of his past service, except in the following cases. So whether it falls under any of these exceptions: A, authorized leave of absence, unauthorized absence in continuation of authorized leave of absence, so long as the post of absence is not filled substantively. C, suspension where it is immediately followed by reinstatement, whether in the same or a different post, or where the government servant dies or is permitted to retire or is retired on attaining the age of compulsory retirement while under suspension. Transfer to non-qualifying service in an establishment under the control of the government if such transfer has been ordered competent authority in the public interest. E, joining time while on transfer from one post to another. So, Your Lordship, even the point number 2 also, Rule
No, it is not covered.
27.2 also, it doesn't cover. So, this will be counted as a normal interruption in service of a government servant which entails forfeiture of the past service. This case falls under that category and doesn't fall under the exception that will be counted as a continuous service. So, in my consultation with the Office of the Principal Accountant General, I have been informed that this service has to be counted with effect from the 15th
Only
January
that
1993, and
15th,
before that, if it is accepted, we are also not just answerable to the state government, but to our higher authorities in the central government also. So since it does not fall under any exception.
What the petitioner is also saying.
So, Your Lordship, we have to agree with the explanation given at paragraph 19 of the petitioner. The petition of the petitioner, Your Lordship. Will that suffice, Your Lordship?
Yes.
Lordship, the other day,
Yes.
I was referring to a case of M.T. Ranla's case, where there was a gap of 7 days between her resignation and appointment, consequent upon the recommendation of the NPSC as extra assistant commissioner.
Yes.
In her case, there was a break of 7 days, clear break, but then in her resignation letter, she has made a mention that to enable me to join in the higher post. So she was working as a UDA, and then she was selected by the NPSC as EAC. So she had to submit the resignation. Unless she submit the resignation in the earlier post, she cannot join in the new post. So she categorically mentioned in her resignation letter that to enable me to join in the higher post. So this honorable court came to the conclusion that, look, your resignation is with a purpose to join in the other post, higher post. Therefore, the gap between the termination and joining in the new post as ESC can be treated as a technical resignation. So when it is a technical resignation under Rule 28 of the CC's rules, 26, then in that case, it should be treated as connected, as if there is no break or gap. Here in our case, there is no issue of resignation also. As Lordship is well aware, in a contract appointment, when the specific date is mentioned in the appointment itself, that your service shall come to an end from this date, then there is no question of issuing any formal termination order also. The moment it comes to an end, everything goes. So there is a clear break of 45 days. So that is what the Accountant General is also saying. I believe I have referred to judgment. Operative portion is from paragraph 11, 12, 13, and 14.
11,
the finding of the learned single judge. This was upheld by the division bench also. But this case is totally different from
It's a different
our case. Yes, there is continuous service. But here in our case, government is also saying that yes, there is a break. And then the Accountant General is also saying that it cannot be treated as a pensionable service in view of the break and kept in the service. So I think that will suffice, Lordship. Much obliged, Lordship.
Learned Counsel for the petitioner, Mr. Sidi Jamir, Mr. K. Angami, Learned Government Advocate for the state respondents, and Mr. Joshua Sheki for the respondent number 5.
Yes, Your Lord.
Respondent number 5. Hearing is concluded. Judgment is.
One thing I have forgotten, Lordship, in respect of Singh's case, Sarjit Singh's case, which my learned friend has referred to, in that particular case also there is no involvement of resignation.
Yes, yes.
It was a continuous service.
No resignation. Yes.
Obliged, Lord.
For admission, item number 24.
Give this book also, okay? Give this book also along with the record, no? Yes.
Lordship, as per the latest office note, the steps which we have taken has been received, Lordship. But
18.8. 18.8 order was such and such. This issue notice returnable in 4 weeks. Okay, so respondent number 1 has received.
yes, but it seems none has appeared today.
Only one respondent.
A sole respondent, Lordship.
Sole respondent. We'll give some more time, maybe 2
Lordship,
weeks.
yes.
Learned Counsel for the petitioner, Mr.
Metaphor.
Metovero is present. Stop. The office note dated 2/9/2025 indicates that the notice on this sole respondent has been served and acknowledgement has been received. Stop. However, when the matter is called today, none appears for the sole respondent. Stop. List the matter after 2 weeks, awaiting appearance of the sole respondent.
Much obliged, Lordship.
For admission, item number 30. I beg your pardon, item number 28.
Your Ladyship, may I please? I filed this petition bring for the quashing of FIR, which is in page number, an extra P, page number 16. This is in FIR.
Page 16. Yes.
May I read out for you? Your Lady? Madam, with reference to the subject cited above, the Konyak Students Union Kohima hereby file a complaint against Mr. Wopang Ilemsong, resident of Merima Village, Kohima, for physically abusing a minor child, Master so-and-so of so-and-so village and Mon, Nagaland, currently residing with the accused. The child is currently studying at Government Middle School, Merima, Kohima, Nagaland. The child has found to be in a very pathetic condition with multiple bruises and abrasions over his body. Therefore, the union rescued and handed over the child to the Child Welfare Committee, Kohima. Thus, in the light of the above-mentioned atrocities meted out to the child by Mr. Wopang Ilemsong, the union urged your competent authority to kindly register the matter and deliver justice accordingly. As such, the alleged accused was summoned to the police station. Then, while I appeared before the police station, he was arrested and kept in police custody. Then, after forwarding to judicial custody, the accused is presently on bail. My lady, I would like to mention that this young boy, Mr. Wopang, is also a government servant. He is staying and working in BHQ Kohima presently. And while he was staying in Kohima, the boy's guardians and relatives requested him to take care of him because earlier the boy was with another family, but they could not contact him frequently. As such, this Wopang Imsong's
with his family, parents, there's another boy who is staying with them for many years. So the same brother, this is the same brother. So they requested him to keep it with him. So during that period, when he came to, that boy came to Nagaland, to Merima, it was late for admission. So Wapang, the petitioner, out of love and concern for the young boy, he went to the school and requested the Merima High School principal for his admission. And there he was allowed and take the admission. And while they were in the process of going to school, Wapang Im Song happens to go to Gauhati again with another one boy of the community unit who was seriously ill, and unfortunately he died. The relative of the accused, victim itself.
Victim.
Yeah. So he went along with the dead body to the border area of Wangdi village and came back. When he came back, the boy is he's sweet as well, loving boy, young boy, but he's naughty also. Sometimes he's drowned. So while teaching him studies, lessons for the exam, and he wants him to grow up to be a very good and responsible boy, the boy sometimes he's drowned and naughty. So out of love and concern, he happens to reprimand and caution in accusedly, like it is shown that he's hit the boy also. But it was all out of love and concern, nothing out of bad or ill feelings. But however, the FIR was filed. Then thereafter, when he was in, FIR was filed, and the FIR, the allegations are a little harsh, which is shown in page number 16. However, my lord, in due course of time, the Konyak Union and the AUs in Kohima, the two apex bodies, they have met and they have entered into a compromise, which is, I will have annexed here in page number 20, page number 24, your lady, your ladyship, page number 24. Yes, Your Honor. The person.
Lordship, I'm appearing for the response, Your Lordship. Yes, Your Lordship. I filed my reply, Your Lordship. Lordship, I have limited submission, Your Lordship, since the compromise agreement has been executed between the parties, Your Lordship, and the respondents, they are no longer interested in pursuing the matter, Your Lordship. They have no objection if the FIR is quashed. Yes, Your Lordship. Just yesterday, Your Lordship, it may be called. Lordship. Yesterday, Your Lordship. For admission, item number 30. Lordship, if I may, before my learned friend begins her submission, I just want to have one preliminary objection in this. Lordship, this is for condonation of delay. Lordship, my objection is with regards to suppression of material facts. Lordship, after the passage of the award, the claimant petitioners, they filed an execution petition before the learned tribunal. That was initially filed in June 2024. Now notices has been issued. Lordship, I have filed those orders in my objection.
Objection, written objection by R2 and 3.
No, Lordship.
R2 and 3. Written objection by claimant number 1.
Yes. Initially, Lordship, if you remember, I was made the sole party, but when I raised the objection, My minor
Okay,
children
okay,
were
okay,
also
yes,
included.
yes, yes.
So in my
That
written
is-
objection, I have only mentioned respondent one, because only one respondent was
Yes.
completed. Now it has been made, my minor children has also been included, 4, 5, and 6. Lordship, annexure, page 16 onwards, Your Lordship. These are the orders passed by the tribunal in the execution case. And lastly, Your Lordship, on 12/12/2024, the claimants were allowed to publish it in the newspaper.
Issue short course steps. Then 2510.
In fact, Lordship, it has been published, and I have annexed a portion of the relevant portion, Lordship.
Order dated 12/12.
And Lordship, this is the,
It is here also.
yes, Lordship, otherwise the whole newspaper is here.
It's okay, it's okay.
So these facts are not mentioned either in the interlocutory application or as well as in the main appeal, Lordship. Now my contention is that, Lordship, they have had the notice of the pendency of the execution case, but they have never bothered to appear before the tribunal.
They are not appearing.
They have not appeared.
Your Lordship,
Yes.
as
So
stated
that
in
is-
the affidavit of the respondent, page 16, Your Lordship, there our learned counsel have appeared, Mr. Edison Maiti, submits that he have received no instruction from the judgment letter, Your Lordship. He have appeared
That is
once.
order dated 16th, Lordship.
That is 16/8.
Yes.
Yes, Your Lordship.
Then after that, he never
After that,
appeared.
nobody appeared. That means they have the knowledge, but
25,
they have suppressed,
Nobody appeared. 12, nobody appeared.
in spite of having the knowledge.
If I may, Your Lordship, regarding the showcase notice, prior to that, on 1/3/2024, the company has already appointed the second counsel to file for appeal before this honorable court. But by her reply dated 21/11/2024, the counsel.
I'm only stressing on the fact that that has never been mentioned either in the IA or in the main appeal, Lordship. Not a whisper, Lordship, about the pendency of the execution case. So they are guilty of suppressing material facts. And whether,
If Your Lordship may.
delay, I'll leave it to my learned friend to explain, and then I'll reply to that.
Your Lordship, if I may, if Your Lordship may kindly come to page 6 of my IA, Your Lordship, so that I may satisfy Your Lordship regarding the delay. Para 7. That the appellant has a divisional office at Dimapur in the state of Nagaland. It has a regional office in Gauhati, Assam. That the appellant received the judgment dated 17/10/2023 through divisional office at Dimapur, forwarded to the regional office for approval and advice in recommending the appeal on 27/10/2023, which I've annexed in Annexure 2. That the Chief Regional Manager, on receiving the file, took legal advice from Advocate S.K. Goswami, and the advocate gave his legal opinion on 25/11/2023, which I've annexed in Annexure 3, causing a delay of 30 days. On receiving the legal opinion, the appellant regional office in Gauhati, Assam, appointed the panel counsel to file for appeal before the Honorable High Court, Kohima bench, on 19/1/2024, which I've annexed it on Annexure 4, but the counsel returned the file on 14/02/2024, which I've annexed it in Annexure 5 to the divisional office at Dimapur, causing a delay of 83 days. On receiving the divisional office at Dimapur, sent a letter to the appellant regional office in Gauhati, Assam to entrust engage other counsel on 29/02/2024, which I've annexed it in Annexure 6, to which the appellant regional office in Gauhati, Assam appointed another impanel advocate on 1/3/2024, which I've annexed in Annexure 7, based in Kohima, to take up the appeal, but it was very disappointing to note that after almost 9 months, the appellant received the council opinion by letter dated 21/11/2024, which I've annexed in Annexure 8, along with the file, causing a delay of 280 days, Your Lordship. That on receiving the files by the divisional office at Dimapur, they forwarded the files on 25/11/2024, asking the appellant regional office in Gauhati, Assam, to appoint a counsel to file appeal. At the meantime, the appellant was looking for a fresh impanel counsel to represent the case, causing a delay of 44 days, Your Lordship. As by going through the statement above, a total number of 437 days was caused by the impanel counsel, whom the present appellant appointed. It has been stated in Ram Kumar Gupta and others versus Har Prasad and another, SCC case 391/2010-1, that the contesting parties should not suffer for the lapses on the part of the council. Relevant portion in para 11. Lordship, the case that was made out by the appellants for restoration of the writ petition was that the learned counsel for the appellant, Sri Gupta, could not appear before the learned judge of the High Court, as at the point of time he was designated as the additional Advocate General of the state, and for that reason, it was not possible for him to appear at the time of hearing of the writ petition, as well as for restoration of the petition. Keeping this fact in mind, the fact that the appellants could not be represented at the time of hearing of the writ petition, we feel it appropriate to restore the writ petition to its original file in order to give an opportunity to the appellant to contest the same on merit. Lordship, and in Rafiq and another versus Munshilal and another, SCC case 788/1981 to para 3, the disturbing feature of the case is that under our present adversary legal system, where the parties generally appear through their advocates, the obligation of the parties is to select his advocate, brief him, pay fees demanded by him, and then trust the learned advocate to do the rest of the thing. The party may be a villager or may belong to a rural area or may have no knowledge about the court's procedure.
Basically, your ground is that the delay was caused due to the council's carelessness or whatever.
Yes, Your Lordship. May I continue, Your Lordship? After engaging a lawyer, the party may remain supremely confident that the lawyer will look after his interests at the time of hearing of the appeal. The personal appearance of the party is not only required but hardly useful. Therefore, the party, having done everything in his power to effectively participate in the proceeding, can rest assured that he has neither to go to the High Court to inquiry as to what is happening in the High Court with regard to his appeal, nor is he to act as a watchdog of the advocate that the latter appears in the matter when it is listed. It is not part of his job. Mr. A.K. Sanghai stated that a practice has grown up in the High Court of Allahabad amongst lawyers that they remain absent when they do not like a particular bench. Maybe we do not know. He is better informed in this matter. Ignorance in this behalf is our bliss. Even if we do not put our seal or imprimatur on the alleged practice by dismissing this matter, which may discourage such a tendency, would it not bring justice delivery system into disrepute? What?
You come to your para 7, last 4 lines, 5 lines.
Yes.
Later, it was again, the file was forwarded on 25/11/24, asking the appellant regional office in Gauhati to appoint a counsel. Then after that, the next date is at para 8/7/2. Yes. So what about that? Because that is not the council's carelessness or council's delay on the part of the council. So this is 25/11/2/7/2. That is 2 months, no, 3 months. Almost 3 months.
Your Lordship, I was appointed as a new and panel advocate on 7/2/2025. Yes, Your Lordship.
Whereas the file was sent back to the regional office on 25/11/24, asking to appoint a new council. So from that day till your appointment on 7/2, see, that is 25/11/2024 to 7/2.
Your Lordship,
What about that?
that in that prior to that 2 months, Your Lordship, there are certain formalities and procedures which the company follow, and they were already in the process of appointing new and panel advocate to select new and panel advocates, Your Lordship.
More than 2 months to select a new advocate. Yes, and then from 7/2/25 to new advocate was appointed on 7/2 and file received on 7/3 after
Yes,
a
Your
month.
Lordship, yes, because this register post ID takes a lot of time, and during that process, there has been a delay, Your Lordship.
But that legal opinion was already there from before. That's why it was not enough.
If Your Lordship may come to Annexure 11.
If the file was received by you on 7/3,
Yes, Your
then
Lordship.
again, what entire file is sent on 44?
After preparing all the appeals and IA, we again forwarded to the company, Your Lordship, to obtain the signatures and necessary formalities, yes, Lordship. 11, page 45. After rectifying by the company, only we are allowed to file the appeal, Your Lordship, so it took time, Your Lordship. Your Lordship, there has been a compromise letter between the claimant and the respondent. My compromise letter is in page 27 of my appeal. Yeah, no, Your Lordship. And also, a sale deed I have given a sale deed where the insurance was not in the name of the owner of the vehicle during that period of time, Your Lordship.
Lordship, my preliminary objection has been noted. Yes. Lordship, your Lordship has rightly pointed out about the gaping holes that there has been no proper explanation. Prior to that, Lordship, after the file was received on 27/10/2023, I'm referring to the statement made in Para 7, Lordship, of the IA, and the legal opinion on 25/11/2023. It was only on 19/1/2024 that a panel counsel was appointed. There is a gap, 25/11/2023 to 19/1/2024. There is no explanation, Lordship. All this time, the file was with the appellants. There is no explanation, Lordship. Kindly note that, Lordship. And Lordship, the allegation that from 1/3/2024 till 21/11/2024, the file was with another empaneled counsel at Kohima. Lordship, this is about 9 months. And Lordship, yes.
9 months.
They have not bothered to even to prompt the empaneled counsel. They have not taken any steps. And no complaint against the alleged counsel has been filed by the appellant. They have done nothing, Lordship. They were sleeping, in fact. And Lordship, the case cited by my learned friend is not applicable in this case. In the present case, no case was filed. And in the case cited by my friend, the case was filed before the Honorable High Court. Yes, there is a difference. Here, case was not even filed. And they have not even bothered to prompt the empaneled counsel for all those 9 months, about 9 months, Lordship. And secondly, Lordship, for 75 days, your Lordship has rightly pointed out. Yes, Lordship, even the doubt of I don't know which date it should be taken. Page 10, para 8. Apparently, as the new counsel advocate on 7/2/2025. And on 26/2/25, the appellant appointed Ms. So, which is the appointment date? We don't know yet.
Yes, my appointment date, Your Lordship, is on 7/02/2025, which is in Annexure 9 of my
Then what?
petition, Your Lordship.
26/2 is another date that has come in.
Yes, that is in Annexure A, where the company have asked me to take up the appeal for this particular
So
case, Your Lordship.
Effectively, these are appointment dates. Yes, it will be 26.
Yes, Your Lordship.
So the more days that you have to explain. And on receipt of the file, Lordship, 7/3/2025, till the filing of the appeal on 22/4/2025, Lordship. No proper explanation has been
Your
given.
Lordship.
Lordship, in this regard, I would like to place one decision by the Supreme Court. This is This is 2012, 5 SSC 157. I'll just read the head note, Lordship. No doubt, substantive rights of parties should not be ignored because of delay, but a distinction must be made between delay of a few days and inordinate delay causing prejudice to the other side. No premium can be given to total lethargy or utter negligence of the state, officers, machinery, agency, instrumentality, and condonation of delay caused by such officers cannot be allowed as a matter of course by accepting the plea that dismissal on ground of limitation will cause injury to the public interest. Lordship, paras 14, 15, 16, 23, 24, and 25 and 29 are relevant in this. Lordship, 29 is, I'll just read it. This is a short para, 29, the last para. Unfortunately, the learned single judge of the High Court altogether ignored the gaping holes in the story concocted by the corporation about misplacement of the papers and total absence of explanation as to why nobody even bothered to file application for issue of certified copies of the judgment for more than 7 years. In our considered view, the cause shown by the corporation for delayed filing of the appeal was, to see the least, wholly unsatisfactory, and the reasons assigned by the learned single judge for condoning more than 7 years of delay cannot be treated as a poor apology for the exercise of discretion by the court under Section 5 of the Limitation Act. Lordship, in this case, the appellants here and 3 minor children are suffering because of the untimely demise of the only breadwinner. That aspect of the matter has to be considered because of the delay. A right has accrued to us that we should receive our due compensation. Lordship, on the question of merit, the 4 grounds have been taken, Lordship, by the appellant. One is the one that has been stated that there is a compromise later between the parties. Lordship, this compromise later was in order to avoid a criminal proceeding against any of us, all of us. This has nothing to do with the accident claim.
This one.
And if we go to the merit, Lordship, they have not taken the permission under 170B. Yes. No permission has been granted. Otherwise, they are not going to succeed in the main appeal, Lordship. Even then, otherwise, Lordship, the delay has not been properly explained, and my humble submission before this honorable court is that the plea taken by the appellant in preferring the condonation application is, to say the least, unsatisfactory, Lord, under the circumstances. No proper explanation has been shown. There are so many gaping holes.
Okay. And
Yes, Your Lordship.
Four, 5, and 6. Lordship, my friend.
First, one, number 2 and 3.
2 and 3.
2 and 3.
by filing this instant application, the applicant sought for continuing the delay of 554 days in filing the amended MCAP against the judgment and award dated 17/10/2023 in MC case number 32 of 2022 passed by the London County External Judgment. The reasons for the delay are mainly set out at paragraph 7 of the application. stated that after receiving the judgment and award dated 17/10/2023 through the divisional office at Dimapur, the same was forwarded to the regional office Gauhati.
Yes.
Regional office Gauhati for approval in recommending the appeal on 27/10/2023. Stop. It is stated that the chief regional manager, on receiving the file, took legal advice from an advocate, and the advocate gave his legal opinion on 25/11/2023, causing a delay of 30 days. So, on receiving the legal opinion, the appellant regional office at Gauhati appointed their impaneled counsel to file an appeal before the Gauhati High Court Kohima bench on 19/1/2024. But the counsel returned the file on 14/2/2024 to the divisional office at Dimapur, causing a delay of 83 days. On receiving the file, the divisional office at Dimapur sent a letter to the appellant regional office at Gauhati to engage another counsel on 29/2/2024, after which the appellant regional office at Gauhati itself appointed another impaneled counsel on 1/3/2024 based at Kohima to take up the appeal. But after keeping the file for almost 9 months, the appellant received the counsel's opinion right letter dated 21/11/2024, along with the file, causing a delay of 280 days. Stop. Upon receiving the files by the divisional office in Dimapur, the files were forwarded on 25/11/2024, asking the appellant regional office in Gauhati to appoint a counsel to file the appeal. In the meantime, the appellants were searching for a fresh impaneled counsel to represent the case, thereby causing a delay of 44 days. Thereby, total number of 427 days delay was caused by the impaneled counsel. Finally, the appellant regional office at Gauhati appointed the present counsel as the new impaneled advocate on 26/2/2025. The files were received by the newly appointed counsel on 7/3/2025. Thereafter, the counsel furnished a legal opinion to prefer an appeal against the appeal judgment and award, and returned the file along with the petition to the company on 5/4/2025 to obtain signature and necessary formalities. The regional office Gauhati Assam forwarded the entire file to its divisional office in Dimapur on 14/4/25 for preferring the appeal. And during this process, there has been a delay of 75 days. The instant appeal was finally filed on 22/4/2025 after a delay of 554 days. The Government Council for the applicant has relied on the case of Ram Kumar Gupta and others versus Ram Prasad and others reported in 2010 1 SCC 391 and Rafiq and another versus Muchilal and another reported in 1981 2 SCC 788 to support the contention that when the delay is the party who would suffer and not the lawyer. But since it is the party whose interest he represented who would suffer and not the lawyer, and that the party should not be made to suffer for the inaction, the omission, or misdemeanor of this council. Learned counsel for the learned counsel for the learned counsel is commander for the present 4 and 5.
5 and 6.
Women responded 1, 5, 6.
5 and 6. 4, 5 and 6.
His objections. And at the outset has submitted that the applicant has suppressed material facts as an execution petition has already been filed in connection with the present MSCA and the same is pending before the executive court. So it is stated that on 16/8/2024, when the execution case was listed, one Mr. Edison Mathai, EDISON Edison Mathai MFTHA, had appeared for the applicant appearance, but thereafter, on the subsequent days when the execution case was listed, none appeared for the applicant appearance. By order dated 12/12/2024, the executing court had allowed the claimant respondents to serve notice by publication in the local daily, and the same was complied with, and such notice was published in the December 17th issue of the Nagaland Express. Therefore, it is submitted that the appellants were all along aware about the executing proceedings, but they have chosen to remain silent about this fact in their application and also in the writing. Your objections start from para 4.
Lordship, explanation is more profound in 7.
Regarding the objection to the condemnation application, the learned counsel submits that the appellant has failed to explain the delay from 26/11/23 to 18/1/24, that is 54 days, when on 19/1/24 the impaneled counsel was allegedly appointed. When the file was returned on 14/2/24, again from 15/2/24 to 28/2/24, there is no explanation for 14 days. Again from 1/3/24, when another counsel was appointed, till 21/11/24, the appellant remained silent. This is like 9 months, not?
Yes, 9 months. As per the statement, also 9 months.
When another counsel was appointed till 21/11/24, the appellant remained silent for long 9 months. In fact, the appellant being a company that deals with public policy is required to act promptly and efficiently when they are dealing with public money. But while the file was pending before the Imperial Council in Kohima, no action was initiated by the appellant company, either to approach the council, but company to later to approach the council, but waited and allowed time to run against them. So, again, from 25/11/24 till 7/2/25, it should be now 26/11.
Yes, it should be. So the number of days also should be.
Yes. Again, from 25/11/24 till 26/2/25, the appellant has failed to explain
The
this,
number of
this
days
period.
also. Yes. Number of days.
And no explanation has been made in the application when the new council was appointed. So, therefore, there is inordinate and unexplained delay in filing the connected initiative, and such praise that the application may be dismissed. Stop. This court has given due consideration to the submissions of the opposing counsels and also perused the pleadings in detail. Stop. On going through the explanation provided in paragraph 7 of the application, there are gaping holes and unexplained delays, especially in between 25/11/2023 to 19/1/2024, and also from 25/11/2024 to 26/2/2024. But most of all, it is difficult to comprehend that an insurance company which is dealing with public money should await the information from the Imperial Council for almost 9 months in between 1/3/2024 to 25/11/2024 to 21/11/2024, without even inquiring about the status of the file. The facts of the present case can be distinguished from the judgments relied upon by the applicant petitioner, inasmuch as in the judgments relied upon, the counsels were already appearing on their behalf before the court, but they failed to appear on several dates, and hence the three petitions have been dismissed for non-prosecution, isn't it? They were dismissed for non-prosecution. The judgments which are relied upon dismissed for non-prosecution, and the court had restored the same due to the fact that it was due to the inaction of the counsel and not the parties concerned. So, however, in the present case, the delay was caused even before the claim/condemnation applications were filed before this court. And in view of the above, this court is of the view that the delay of 554 days has not been explained properly, and in order to delay has not
Lordship, there is another IA, and the main appeal also order needs to be passed.
No, see, main appeal is not admitted, no?
Yes.
Because only if the condemnation is allowed, the main appeal will be admitted.
The only problem that we may face perhaps maybe if there is no order, that in Lordship may pass as one line order in the main appeal.
The main appeal will say in view of the dismissal.
Yes,
of-
yes, yes.
In view of the dismissal of IA.
Yes, yes.
54.
Yes, 50.
54 of 2025, this
That is for a stay.
here also see, here the order passed in IA 54 is
Much obliged.
For admission, item number 28.
Lordship, number 3, Your Lordship, relevant portion.
Yes, my lord. My lord, my humble submission is, though the case is registered under 1152 of PNS and 115 is a compoundable offense and the 75 JJA is not a compoundable. However, since the matter has been yes, I'll leave it to your lordship, my lord. And my lord, kindly allow me, kindly excuse me because I have one part matter. Much obliged.
The present petition under section 488 of the BNSS has been filed praying for quashing of the FIR and all the prosecutorial criminal proceedings. In GR number 46 of 2025, in connection with Kohima Women Peace case number 0005/2025 under section 115 clause 2 BS Red section 75 Justice Act. Reverend Council Mr. Nagaland for the motion, as well as Mr. Chiba for the BP, and Reverend Council Mr.
M. Solo, Your Lordship. M. Solo. Four is 2, 3, and 4.
We can see the case of the petitioner is that an FIR was filed on 14/5/2025 before the officer in charge, Kohima Women PS, by the President and General Secretary, open bracket, Priswana number 2 and 3, close bracket, of the Punjab Students' Union, stating that the petitioner had abused a minor child who was residing with the petitioner accused. Basing on the complaint, the case was registered. The Kohima case number 0005/2025 under section 115 clause 2 BNS section 75 Justice Act. During the here charges is provided.
I'm not aware, Your Honor. Actually, in the previous order, the proceedings has been stayed, in fact, in the first order. Yes.
During the period of investigation, the family of the victim and the family of the petitioner being close and well known to each other for the last 30 years. decided to arrive at an amicable settlement in the matter. Accordingly, on 24/7/2025, the meeting was held at Kohima between the Pongyang Union Kohima and the Au Union Kohima. After a prolonged discussion, a compromise deed was executed between the petitioner and the respondents number 2, 3, and 4 / complainants.
And the father of the victim, Your Lordship. Respondent number 4.
Respondents number 2, 3, 4, and 5 / complainants and father. Where's the compromise deed?
24. Page 24, Annex D.
Lordship, here the brother, he have signed, Your Lordship. The brother of the...
Oh, the brother.
Yes, Your Lordship, family, not the father.
You say brother.
Brother of the accused. This is a receiver of the victim.
Deed of compromise dated 24/7/2025 is annexed in the application, and it shows that the petitioner and the respondents herein have agreed to settle the matter amicably, and it is stated that in view of the friendship and brotherhood between the two communities, and also in view of the good relationship between the families of the victim and the accused, the second party, being the accused, apologized and sought for forgiveness to the victim and his parents, relatives, and union members, and the first party, being the complainants and family members of the victim, after considering the plea of the accused in the presence of parents, relatives, and union members, and forgiven the accused person. And it was also agreed in the compromise deed that the parties shall not pursue the matter in any court/platform, and neither party shall pursue the case against each other, and honor the agreement entered into between them. It is also stated in the petition that the complainants, respondent number 2 and 3, complainants are 2 and 3, isn't it? Number 2 and 3
Yes, Your Lord.
have withdrawn the FIR by a letter dated 25/7/2025, which is addressed to the officer in charge, Women Police Station, Kohima, Nagaland. The letter dated 25/7/2025 has read that the FIR dated 14/5/2025 may be withdrawn and the matter be closed in the interest of all parties. In this letter also, it has been indicated that the parties have entered into a compromise and that they shall not pursue the matter any further in any platform or before the court. The respondents number 2, 3, and 4 have also filed their affidavit, wherein it is stated that the matter was already settled. The matter has already been settled between the parties through a compromise deed dated 24/7/2025, which was executed between the petitioner accused and the respondent number 2, 3, and 4, along with all the family members and others. Therefore, it is stated in the affidavit that the respondents have no objection if the present after going through the readings and after hearing the process for the petitioner as well as the respondents, before that you say, Learned VP Mr. E. Tibapo has submitted that section 115 clause 2 BNS is compatible. However, section 75 of the Juvenile Justice Act is non-conformable, and therefore he submits that the present petition may be dismissed as the compromise cannot be entered into in a non-conformable offense. However, he fairly submits that, considering the settlement arrived at, he leaves the matter to the wisdom of his court. Then after that, he come and always consider the submissions of the non-constitutional parties as well as produce the pleadings, and is of the view that as the matter has been amicably settled between the accused and the complainant, respondents as well as the family members of the victim, and there is no likelihood of the criminal proceeding against the petitioner pending in conviction. This court is of the view that it would be a further exercise to continue with the trial of GR number 46 of 2025 pending before
CJ. CGM.
Much. For orders, item number 31.
31. No? Your Ladyship, I've received instruction. So I'll file my wakalatama later. And item number 31. The respondent, yeah. Respondent Chumungswa. Yes, sole respondent.
Mr.
Hello. Yes, sir.
Submits that he has received instructions to appear on behalf of the sole respondent, and this for how much time?
3 weeks time.
3 weeks time to file. We have filed a Bagaimana.
No, I've not yet. I'll file.
To file this Bagaimana and the objections he made. Where's the petitioner?
Lordship, the state has preferred a
Oh, this is presented by state.
Lordship. Lordship. Criminal.
For orders, item number 32.
Lordship, here for the sole private respondent, I have instructions to appear, yes, my lord. So I'll be filing the wakalatama within the course of the day.
That
Lordship, I'll be filing my wakalatama today.
anything?
No? If it can kindly be listed after the Puja vacations, then.
Much
Deeply
obliged.
obliged.
For orders,
If
item number.
If that, item number 32, if a date can be fixed, Your Lordship, because the leading counsel is from Guwahati. Any date, Your Lordship.
Ninth, my lord.
Lordship. Okay, much obliged, Lordship.
Much obliged.
For orders, item number 33.
May I please, Your Lordship? Your Lordship, I'm appearing on behalf of B.N. Sharma for Respondent 1, who is also representing 2 and 3. Your Lordship, I'm entering appearance for the first time. Your Lordship, we have not yet received the appeal memo from the appellant. And as such, let the appellant be directed to serve copy of appeal memo to us.
No, Your Lordship. For stay, Lordship.
MKO. Respondent 1. 1. Yes, who is also representing 2 and 3.
Yes.
Yes, Your Lordship.
Yes. Much obliged, Lordship. No, Lordship. Obliged, my lord.
Much obliged, Your Lordship.
For orders, item number 34.
May I please be, Lordship? Lordship, I'll be appearing for respondent number 1 to 7. Due to Lordship bad road condition, I could not come to Kohima today. Lordship, I have already the power. I'll be filing it in the next date, Lordship.
Mr. Sharif proposes for respondent number 1 to 7 and submits that he will be filing his fatwa within how much time?
Lordship, maybe after Puja vacation. In the meantime, I'll file the Wakalapnama.
There is a condemnation application also.
Lordship, in the next day, we'll hear the condition of deliberation. It is for 19 days only. I have no objection, Lordship. It is just for 19 days only.
Is the matter after the adjournment? Will the counsel for the appellant
Deeply obliged.
My lord, I just received information that the counsel for the respondent number 2, she has some emergency. So if it can kindly be listed after 3 weeks, I'm for the petitioner. The counsel for the respondent informed me. I'm deeply obliged. Good mention. Hoshina, Ajiro.
I charge it High Court law post creation law against the registry, no?
All like that.
The law, very important for us.
All the best.
Oh, thank you. Determination question, no?
Kevin, football league, let's go. Kili le mala zilio. Ami, kiba lo di ko?
Hello, computer section. Awe, Pugo, Vincent, Molo, Tushi. Over there.